Mr. Ashok Kumaru, a well-known name for our intellectual property rights and also Information Technology Act. Today, we'll be talking about litigations in intellectual property rights. At the juncture, I need not to tell you about what is intellectual property. Every one of you are well aware of the meaning, concept, and components of the intellectual property rights. We are going to have 1 hour plus or 1.5 hours on only litigations of the intellectual property rights. It may be copyrights, it may be about the trademark, it may be the patent or GI, whatever it may be. This is the structure of your lecture today. When you talk about the intellectual property rights, litigations related to that, we have two different kinds of the phases. First phase is before sanction or granting the registration or granting the certificate to the application filed by the individual or owner. Second is about the litigation after registration. That is the infringement of the rights. Whereas in the first is in the process of granting the registration, a different kinds of litigations will be there. Once you file your application, during the time of verification by the registry, there may be some objections. At that time, the litigation starts with the applicant. He will create some kind of, these are the objections we have. Then Ashok Kumar, like advocates, will go and explain him, these are not correct. You have to accept for the particular. After hearing that, the registry will accept and go for publication. During that, again and again, we'll have a lot of litigations during the path. Once litigation, this particular application is published in a journal, maybe trademark journal or patent journal, what it may be, pre-grant oppositions will coming up. So many issues will come. Then it is a duty of the applicant to satisfy the registry about their ownership in that particular part, and there should not be any identical part of it. Then the litigation ends from the date of the granting or sealing the particular trademark or patent or whatever that may be among the IPR. At the juncture, again, if you forgot to file objection petition, then your role starts. You can start your role again there. You may go to the tribunal, or you may go to the civil law or common law. We are not registered. Question the validity of that particular registration sanction there. Then some more litigations will come about the infringements, or some other people may file against you for the infringement. So litigation intellectual property is a continuous one from the date of you owning this till the expiry of that particular rights. If it is a patent, it's 20 years. Trademark lifelong. You go on renewing it. It will happening it. Your copyrights again, you'll be having a lot of lifetime. Your lifetime plus 6 years after that. Like that, during the lifetime of that particular property, you have to face many litigations, or you have to file many litigations against other party also. A lot of amounts are spent upon this. It's a very rich litigation part of it. Damages are asked, or companies are asked in huge millions also. We have seen the many cases filed by the Samsung or Apple or Ranbaxy or Pfizer. So a lot of people will be questioning about the sanctioning of crores of rupees or millions of rupees for this particular purpose. That's why we say the litigations of intellectual property are very valuable. Everyone is required to know how to curtail the litigation so that they can save some money. You may earn a lot of money as a royalty. Equally, you have to pay in defending your case or filing the case, protecting your rights. Both the way you have to pay the water. So this is a very critical issue. This is where our Kumar will be talking how to minimize the expenses, how to improve the rights of protection. He is the expert on this. I request Mr. Kumar to take the class and explain about the litigations at every stage. Thank you, sir. I welcome you to the board.
Thank you, Narasimha Rao garu. I will today be talking about IP law enforcement and litigation in India. Now, apart from what Mr. Narasimha Rao said, there are four important aspects for an intellectual property. First, of course, is filing. Then, second is prosecution. When you say prosecution, it is you completely undergo the process of subsequent processes that arise after filing, and then you obtain the intellectual property. Then after that, it is enforcement. Enforcement is where you enforce your right that is statutorily granted by the respective departments. Then you have something called under valuation. Valuation is how do you evaluate your intellectual property? Because just taking intellectual property and keeping it with you doesn't make any sense unless and until you put it to practice, you start manufacturing, or you license it out, or there is a transfer of technology, or things like that. Now, what I'll talk today is purely on enforcement and litigation, which I do on a regular basis, day to day. Can I operate this, Dilip?
PPT, you may ask Dilip or you can both
Sir,
of
I can shift it, or maybe I can transfer the rights to you.
No, 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 no. You shift it
Okay, sure.
because, okay, go to the next slide.
Sure, sir.
Now, these are all the forms of IP. I mean, I don't need to go through this. Patents, copyrights, GIs, designs, protection of plant varieties, semiconductors, biological diversity, trade secrets, confidential information. Now, in all this, except the last, that is the trade secrets and confidential information, rest of the intellectual property are all coded. That is, you have a law written down and then promulgated by the parliament and enforced by the courts. Right? Next slide, please. Now, what is obtaining a right for IP? See, for you, it is not a must for you to file a trademark in this country.
please, everybody mute your mics, please. Dilip, take care of the mics.
Yes, sir.
Okay. See, obtaining a right for an IP. What exactly is obtaining a right for an IP? When you get an IP, can I proceed, Dilip?
Yes, sir.
Okay. When you obtain a right for an IP, the right for an IP is a statutory right. What the statute gives you. Now there are two types of law that work. One is the statutory law and second is the common law. Now let me tell you, in India you need to have file for a registration of a copyright or for a trademark. But then still you can use a trademark. But insofar as patents and designs are concerned, if you start using the patent or the design, you will not get the patent or the design because there is something called as the prior art that will be found out. Now, common law rights exist in trademarks, copyrights, biological diversity, trade secrets, and confidential information. That is, I don't need a statute to protect my right. All I need is a common law right, which is a prior user right. That is why there is this difference of passing off and passing off an infringement under trademark. Passing off is a common law right, and passing off happens when your trademark is not registered, and infringement happens when your trademark is registered. Then next is patents and design common law rights may exist, but is not enforceable. Who entered the market first could always be a question, whether I brought in the technology first in the market, but it may not be enforceable. That is, if someone else copies, you may have to just watch him, doing business after copying your technology. Then under the trademarks, you have very important wisdom, or very important wisdom which says Prior user is a powerful user under trademarks. Now, actually, I am taking one more session for Russian Federation states about 3 days later, because in Russian Federation states and in certain European countries, prior user is not recognized. First to file is what is recognized. But in India, you have a prior user, is a powerful user. And first to enter market is also under copyrights, when did you first, let us take your published book. In fact, I'm writing a case, for one of my clients who's an author and who first wrote a book. Based on the book, a movie was made, and then the producer made a lot of money, while my client, who was an author, was not in a position to make money. All that she asked was for credits, even that was not given. So we went ahead, filed a suit and a criminal case. In fact, we got an injunction in the suit, so we could remove that movie from YouTube by asking YouTube to remove the movie throughout the world. It was a very well-known movie. I will not mention the movie, but a very well-known movie, Telugu movie. The next is statutory right. Registration gives you a statutory right. Once you have a registration, the statute recognizes your intellectual property. Now, I made a statement saying that, for a copyright or a trademark, you don't need a registration. But then a lot of people want a registration for the trademark as well as the copyright. Why is it that they need a registration when when a registration is not must? So let me take copyright first. Now, under Copyrights Act, you have, once when you file a registration, what happens? Once a registration is given to you, and if that work is copied, when you go before the court, all you need to tell the court is what was copied, and you don't need to establish that you are owner of that work, because already there is a certificate. In the event you don't have a certificate, it becomes incumbent upon you first to establish that you are the owner before the court, and then later tell the court what was copied, and then whether it was complete copying or partial copying or whatever it is. Then under the designs and patents, common law right is not that distinct, so registration is necessary to be taken. Next, Dilip, are you setting it up?
Yes, sir. Is it fine?
Yeah, that's okay. So how do I move this thing? Just my key?
Sir, you can just tell me next and I will move it.
Okay. Okay. One benefits of obtaining a statutory protection, it is a constructive notice. See, notice to others. See, whenever you file a trademark, why is it that we put TM? TM does not mean you got a trademark. Once you get a trademark, it is R within the circle. But people also put TM, which is a declaration to the world that he has adopted the mark, and then he has filed for the application, and that no one else should adopt the similar mark. Then it defeats the claim of an innocent infringement. See, though there are judgments, I will deal with some judgments at the end of the PPT, which say even if there is an innocent infringement, still courts have to grant injunction. So this claim of innocent infringement is defeated when you have a statutory protection. Then it establishes the jurisdiction to file legal proceedings at the place of the plaintiff or the owner. So this I'll have to be a bit this thing. In so far as trademarks and copyrights are concerned, suits are filed at the place where the owner is ordinarily residing or carrying on his business. Such type of a provision is called as a non-obstante clause or a non-obstante provision, and it overrides section 20 of the Civil Procedure Code, which says all suits have to be filed in the place of the defendant. Now, with regard to the Patent Act very clearly says that an infringement suit has to be filed at the place where the infringement has happened or where the defendant is residing. While the Designs Act is completely quiet on this. in fact, I've been handling a lot of matters where the fundamental question of jurisdiction was always raised when I filed the, suit for piracy of design. It is there. It is called as a piracy, not an infringement. So there, what happens is I relied upon the Copyright Act because once a design is given to you, copyright is also given to you for that for a period of 15 years. That's what the law says. So I had taken the stand before the court saying, under Copyright Act, when the plaintiff can file the suit at the place where he is residing or ordinarily carries on his business, and once when such mention is not available under the Designs Act, automatically you can rely upon the Copyright Act. But there are judgments of the Madras High Court which say no, no, you cannot take the Copyright Act into consideration, but you need to take the Patent Act into consideration for design because it is called as a design patent. So you need to take into consideration, the provisions of Patent Act, which says a suit for infringement has to be filed at the place where the infringement is happening, or where the infringer is residing, or where the defendant is there. Now, cause of action is also not very strong in so far as patents and designs are concerned, while cause of action is quite strong in trademarks and copyrights. In fact, I filed a suit in the civil court where both the defendant was in Guntur, the plaintiff was in Guntur and the respondent was in Vijayawada. But I filed a suit in Hyderabad. I was able to get an injunction on the cause of action arising here. So cause of action can be a very strong point when once there is a registration in your favor insofar as IPR is concerned. Then the registration also establishes presumptive right of owner to enforce the IP across the country. You can enforce it once you have a registration. You can enforce the IP across the country. Other companies may not adopt the IPR. Once when you are registered, people will know that you are registered, and then they will try avoiding, adopting a similar trademark or filing for a patent for a similar technology, or with regard to copyrights and designs also. But the benefit of obtaining a statutory protection also is a very good basis for seizure of counterfeit, infringing products and label. I was quite recently, about 6 months back, involved in a counterfeit raid for one of the well-known perfume companies from UK. So there they had a registered mark, so it was easy for us to do the counterfeit seizure of counterfeit material.
1 second, Mr. Ramkumar. Can you
Yes,
increase
sir.
the audio?
Sir,
Your,
audio settings are appropriate, I think, over here. I'm able to hear clearly.
please increase your audio.
Okay, sure, sir.
One. Yeah, is it fine now?
Yes, it's okay now.
Then, yeah. So the last benefit of obtaining a statutory protection is you can stop importing of infringing products. Now, for Aditya Birla, I appeared in one matter where Chinese are the world's best copycats. So the Chinese had Aditya Birla had a particular brand for a broomstick, the one which you use to sweep in your house. For that broomstick, there was a particular brand, and that was made out of natural material, that is the grass, the relevant grass that is used there. But Chinese came out with a plastic broomstick which was looking exactly like the way how Aditya Birla was manufacturing, and it had the same name. So these people came to me. They said, "Sir, this is trying to be imported into India." So I got an order for stopping of the goods at border checkpoints, which is called as border regulations. Which is a very important thing. So you can stop import of infringing products into the country if you have a registration in your favor. Next slide, Dilip. Dilip, next slide.
Yes, sir. Moved.
Now, original jurisdictions, common law legal system, original jurisdiction is a court where which has got the power to hear a case for the first time. That is, in to put it in very simple terms, in India, if you are filing an IP matter in Delhi, Bombay, Calcutta, Madras, and Himachal Pradesh, then it has to go to the High Court. In the rest of the other places, it has to go to the lower court, that is the district court. So, section 134 of the Trademark Act says that any infringement suit or a passing off suit has to be filed in a district court. So, a court which is the chief judge of the district court is the person who takes the case. He may deal it on his own, or he may allocate it to any additional chief judge. Then, next slide. Okay. Now, this is the hierarchy for civil cases. You have the Munsif's Court and Small Causes Court, which does not come here. But then you have the District and Sessions Court, Court of Civil Judge Senior Division, and Civil Judge Junior Division. Now, Civil Judge Junior Division, if you see the latest Commercial Courts Act, the amendment that happened in 2018, there is a proposal to appoint junior civil judges as commercial court judges under section 3. There is an amendment to section 3 where not just the district, the chief judges court or the additional chief judges court where the pecuniary jurisdiction is 1 crore. If you are filing a commercial suit less than 1 crore, then it will go to a junior judge, and it is yet to be established because the High Court has not yet given the notification. But insofar as IPR is concerned, because IPR also goes to the what is called as a commercial courts. So if suppose your claim is less than 3 lakhs, or if the claim is less than 1 crore, let us take 10 lakhs, 15 lakhs, it will go to the junior civil judge as per the Commercial Courts Act. Then above that, either there is an appeal to the High Court, or the original jurisdiction may lie in the High Court in the other metropolitan cities where I told you. Then over the orders of the High Court, you can go to the Supreme Court. So this is the hierarchy of the courts for the civil matters under intellectual property law. Next slide, please. Then, jurisdiction and courts, all infringement, passing off, or piracy suits to be filed before the chief judge of the concerned district. It could be allocated to the additional district judge. I told you that. If the jurisdiction falls in Delhi, Bombay, Calcutta, Madras, and Himachal Pradesh, it becomes the original jurisdiction. Next slide, please. I want to know if I am too fast, if people are able to understand this.
Yes, sir. It's fine.
It's fine. Okay. Now, dispute resolution model. Before authorities under the IPR law, it is the registrar of trademarks when you file an application, or when you file an opposition, or when you file a rectification. Right? It is before the registrar of trademark. Opposition and rectification can also be before the the IPAB, but it comes under a different circumstance. Then controller of patents is the first authority. Then registrar of copyrights is the first authority. Then controller of designs and registrar of GI. They are 1 to 5. They are all the first authorities where you file an application and prosecute. Now, IPAB, Intellectual Property Appellate Board, is an appellate board which sits on the orders of all these 5 registries. That is how the hierarchy has been built up. So, Intellectual Property Appellate Board is is in Delhi, and now they have benches across. Quite recently, it landed in serious trouble where they were not able to sit properly and then proceed with the cases. But I think quite recently there was a writ filed in the Supreme Court, and the Supreme Court has asked for explanation in spite of the president of IPAB being appointed. But then that is the way how the hierarchy is set up. Next slide. Then before judicial authorities, it is the district court, original jurisdiction of civil court. Criminal jurisdiction also comes before the the criminal courts. Then High Court's original jurisdiction with the High Courts and appellate jurisdiction with the High Court. Like the way how I told you, once when there is an appeal, suppose you file a infringement suit in the district court in City Civil Court, Hyderabad, you suffer an order, either it is a CMA or a CRP before the High Court. So that is how the the appellate jurisdiction arises. Next slide. Now, under the Trademark Act, what are the provisions? Section 134, institution of suit in district court, infringement when registered, passing off when not registered, passing off when there is also a prior user. Now, this is very important because there is one very important judgment of the Supreme Court that was passed recently, which is Sulochana Bai. Sulochana Bai's case, very, every professor who's teaching trademark law, the judgment, because the judgment completely talks of what is prior user and how two registered users, when there are two registered users, then what arises between them. So one cannot file an infringement suit against the other, but if one of them is a prior user, he can always file a passing off suit against the other registered owner. Then section 124, there is one more provision which is stay of proceedings. When stay of proceedings when validity of the mark is questioned. So let us take, I have filed a suit in the district court, and then suddenly I find that the mark that has been, the defendant finds that the mark that has been filed by the plaintiff is not valid. There are various points for validity of a mark. So let me put it in simple terms. When he thinks that the mark is not valid, he can file a rectification before the registrar, and before filing the rectification under section 124, he will file an application before the relevant civil court, and then he will say, please give me 3 months time for me to file a rectification before the registrar of trademark. And once the rectification is filed, I'll come and report the same court, and then this proceedings can be stayed. Act. This is exactly opposite to the entire of the Trademark Act. Now, under 142, if a person receives a legal notice, let us take, I am giving a legal notice to, or A gives a legal notice to B and tells B, look, you have copied my mark, so you stop using the mark, which is called as a cease and desist notice, technically under the IP law. Now, what does the person receiving the notice, what is the remedy he has? He can approach a local court under section 142 and seek for a declaration under certain grounds, whatever those grounds are, that the threat is not, is a groundless threat, and that the person who is threatening can be stopped from issuing further notices. Now, this 142 is slightly a complicated law. It has been, it is copied from the British law rather, but very interesting topic. When you discuss section 142, how, and also suppose I file a 142 suit. At a later stage, this suit can with a suit of either of amendment that is filed by the defendant in my suit. See, I received the notice, so I file the suit. I am the plaintiff. The person who has sent me the notice is the defendant. So the defendant at his place, if he is a registered owner, or if he is not a registered owner at the place where the passing off is happening, can file a suit for passing off, and this suit, which is filed under 142, can be culminated in the passing off or the infringement suit. Then you have section 102, 103, and 104, which are criminal proceedings that can be started by filing with a police complaint. One is you can file a police complaint, or you can directly, there is also one more provision, 107. I am not mentioning using the symbol R even without his application being granted, you can directly complain to the registrar, which is 107. 102, 103, and 104 are relating to falsely applying marks to the goods or services or falsification of the mark to the goods or services. So this is purely a criminal proceeding under the trademark law. Next slide. Yeah. Now, what are the types of orders that I can get? Now, under trademark law, section 1 very clearly talks of the types of orders you can get. Now, 135 is very exhaustive. In fact, if you take either the Patent Act, Trademark Act, Copyright Act, or the Design Act, unlike acts that are there in this country, these acts actually define or tell what is the nature of that can be passed by the court. So, if you read 135, it very clearly says, first, there can be an ex parte order when it is not contested, and when the plaintiff is able to make out a prima facie case, balance of convenience, and irreparable loss. The ex parte order can be to injunct a person not to use the mark. Apart from that, the ex parte order can also be to seize, infringing goods under Order 26, where you seek for appointment of a commissioner. You can go to the place, raid the place, and seize the material. These are the two ex parte orders you can get. Now, under the contested order, you can also get injunction and as well as appointment of commissioner. Now, there is one very interesting aspect. You have three different types of orders here: Mariva order, Anton Filler order, and John Doe order. Now, Mariva, Anton Filler, one is seizure, another is stopping the company from manufacturing and things like that. Then John Doe order is a very interesting order. Now, to file a John Doe order, it is called as Ashok Kumar order in India, right? There's one case filed by one Mr. Ashok Kumar where he sought a John Doe order. John Doe order is against unidentified people. Like someone is playing, let us take the cable network is playing a movie which got released recently. Now I don't know how many people are looking at it, from where it is getting broadcasted and all that. What I can do is I can file for a John Doe order. Unidentified defendants is what I write in the cause title. Then I file this application before the court, and then the court can give a John Doe order saying anyone infringing this will stop forthwith immediately. Now, John Doe orders are not permanent, because once you get to know the type, the identify the defendant, slowly the effect of the order will come down, but then the injunction will stay. So at a later stage, it will become a simpliciter injunction order under Order 37, Rule 1 and 2, or Order 39, Rule 1 and 2. Then, under the Trademarks Act, one interesting feature, if you read 135, is it says damages or accounts of profits. You can't ask both. You can't ask for a damage and you can't ask for accounts of profit. Now, what is a damage? Damage is the prospective loss that you have undergone when the person has copied your mark and then manufactured similar goods and then sold it. When you claim for damages, it has to be something near about the damage that you have incurred, and it should not be as a penalty on the defendant, right? Suppose you had incurred only 20 lakhs, ask for 22 lakhs or 19 lakhs or something. You can't ask for 2 crores because you don't want to punish the defendant. It can't be a penalty on the defendant. Then accounts of profit is a much more purposeful order that can be sought. Now, accounts of profit is you put the burden on the defendant. What you tell the court is, look, he's manufacturing similar products, and I found out that he has been manufacturing similar products for the last 3 years. So what he has to do is he has to submit accounts. For that, a commissioner can be appointed, or in 1 or 2 cases, I even got a chartered accountant appointed as commissioner of the court, where the accounts were given to him and the accounts of profit is kept. Now, accounts of profit also comes in another, event where the courts don't agree to give an injunction, but they say, let us wait for the outcome of the suit. If in the final decree it turns out that there is an infringement, then this accounts of profit will be maintained by the defendant till such time, and at that time, whatever is the damages that has been incurred can be given to the plaintiff. So accounts of profit works in 2 or 3 different ways. Now, next is order for delivery up. Order for delivery up is very simple. You ask for appointment of commissioner under Order 26. The commissioner goes to the concerned place, then he seizes material, puts them, in one place. There are 2 types of seizures. One is called as a symbolic seizure. Another is called as a physical seizure. Now, symbolic seizure happens when the property is virtual. Like, suppose, let us take, you are appearing for Adobe, and then you are going to a place where they have pirated software. Now, in that company, there are about 200 systems. You can't seal all the 200 systems and put it. What you will do is you will take 1 or 2 systems, you will tape them and say this is a symbolic seizure. None of the systems will use the pirated software of Adobe or unlicensed software of Adobe. So that is a symbolic seizure. Then there is a second seizure which is called as a physical seizure. Physical seizure is where the advocate commissioner goes either with the protection of police, or if there is no protection of police, he can seek from the local police station. He goes to the place, and then you can what he can do is he can enter the premises, seize all material. Then what he can do is he can seal all the material in one room, dump all the material in one room and seal it. That is called as a physical seizure. Generally, in a physical seizure, what happens is the commissioner takes 1 or 2 infringing material for that to be produced in the court. So that is one way of doing the seizing. Then preserving infringement goods and other evidences. There is a regular method where the infringing goods are put in a room and then locked. Then restraining defendant in disposing of his assets, which adversely affects plaintiff's ability to recover a damage. Now, this is a very, very innovative provision that has been provided. Now, let us take, I have raided a place where the person is manufacturing detergents, soaps. Now, detergent can also be a cottage industry, where you get all the regular chemicals and then you start manufacturing a soap. Now, after the raid is over, and after he has copied my mark and then he has made his money, he can't shut down his business and then run away or go invisible. So what I can do is I can ask for the assets to be frozen, whatever assets. That is why generally what we do when we find that the infringement is happening in a particular good, which is very simple but very high sales, like detergent cakes, or what is called as disinfectant liquids. All these are, they are manufactured in small amounts but exhausted, the sales will be very huge. In those cases, what we generally do is we appoint an investigating agency. The agency will go about, find out what are all the assets that the person has got. Then we ask for an order from the court saying direct the defendant not to dispose of his asset, so that my ability to recover after the decree is given is still preserved. Now, next slide, please. Yeah. Now, jurisdiction. 134 infringement place of the plaintiff. It's a non-obstacle clause. I told you under groundless threat. Also under groundless threat, it is a section. Under groundless threat, it is a place where the threat has been received. So the person can file there. Suppose I receive a legal notice, I can file it in Hyderabad. Now, Section 20 CPC does not come into consideration because the provision of law starts without without prejudice to the other provisions of law. Get the book. I'll just read out that in under these provisions, Section 20 doesn't come into play. So give me the trademark. I'll just read out the provision. 134. 134 says, notwithstanding anything contained in the Code of Civil Procedure 1908. Those are the words that are used there. Notwithstanding anything contained in the Civil Procedure Code. That means Section 20 will take the back seat. Though there are judgments by the High Court saying the provision of 134 only expands the jurisdiction, it does not relegate Section 20 as OTS or not workable, but it was only expanded the jurisdiction under 134(2). Next slide, please. Okay. Now, what are the defenses that you can take under the trademarks as a defendant? What can be taken? Now, they are also provided under the law. First is trademark is not a valid mark, right? It is indicative of the goods. It is indicative of the nature of the goods, quality of the goods. That is Section 9 and 11 of the Trademarks Act, validity of the trademark. But let me tell you, civil courts do not have jurisdiction to discuss or to look into the question of validity of a mark, because validity of a mark is the jurisdiction of the registry, not the civil court. So suppose if someone takes a ground that this mark is not valid, hence the injunction cannot be given, then his argument is not sustainable. Then next is rectification pending. Suppose there is a rectification pending, I told you under Section 124, there can be a stay granted because there can't be two different orders on the same subject matter. So multiplicity of orders is avoided by getting a stay. Then honest and concurrent user, Section 12. This is very important. Now, what is honest and concurrent user? Let us take, you have a particular drink called as, this actually happened with one of my clients. There was this drink in Vizag called as Surya. I don't know if they are still there because this came to me almost about 15 years back. Now, the person who was manufacturing this drink in Vizag had a registered mark in his favor, but there was also one more person who was manufacturing a similar drink in Orissa. Even that was called as Surya. Now, there was a problem which arose when we wanted to file a infringement suit against that person. When we filed it in Vizag, he took the ground of Section 12, saying, I also was using this mark for so many years. I have the proof. I can show, though I'm not a registered owner, I've been using this mark for almost 7 to 8 years. Then finally, the matter was settled out of court. But honest and concurrent user is a very strong defense for the defendant. Now, the fourth point is acquiescence. Acquiescence is that specific act of the plaintiff, not by the defendant. Acquiescence is an act by the plaintiff where he sits by and sees the defendant copying his mark and then becoming famous. So when you allowed him to copy the mark, you kept quiet. When he was copying your mark, you kept quiet. When he used it for 2 years, 3 years, you kept quiet. But after 5 years, when that the defendant started becoming very famous, and when you started feeling the pinch of his using your mark, then the defendant can take a claim saying the plaintiff has acquiesced himself for the usage of the mark by me. So acquiescence comes into play. Now, acquiescence is a very, very strong defense, and if you have acquiescence in your favor, the defense can really create problems for the plaintiff in not getting an order. Then, next defense is prior user, where the defendant says that I am a prior user than the plaintiff. Now, the wisdom of law under the Trademarks Act is prior user is a powerful user than a registered user. Prior user is a powerful user than a registered user. Now I'll answer all the questions about acquiescence being 5 years and all that, but then acquiescence under the claim of acquiescence before the registry is different, and the claim of acquiescence before the civil court is slightly different. Now, prior user is where the defendant had been using the mark prior to the plaintiff. Now, let me tell you one thing. If I had been using a mark for years together and I have not registered the mark, I am still a very powerful user. That is, even if another person registers a similar mark and gets the mark registered in his favor, that is, that mark is a registered mark, still I can stop him under prior user, which is, it is not actually section 38. I will tell you the correct provision. I think there's some mistake there. Okay, then the last defense that can be taken is marks are completely dissimilar. That is one defense that can be taken, saying marks are dissimilar. There is one more defense that can be taken, that a claim made to a particular mark. Now let us take, you have geometrical figures like square, triangle, circle. So I was, a case was filed against my client. I was appearing for one milk vendor called as Tirumala Milk, and Heritage, the well-known milk producer, had filed a suit against my client, saying my client was using the oval shape in the name, the oval shape of the mark in the name. So I took a ground saying there cannot be any registration for a geometrical figure. I can use a oval shape as is being used by, the Heritage milk. And I also took a ground saying that zero was the invention of Aryabhatta. So you can't go about saying that I can't use and things like that. So anyway, that suit finally got dismissed, where it was held that yes, geometrical shapes cannot acquire a trademark. Next slide, please. Now, copyright. Now, provisions under copyright are Section 55, Civil Remedies of Infringement for a Copyright. Now, what exactly is an infringement of a copyright? Now, there is something called as substantial copying and, not a substantial copying. But let me tell you this. Suppose you had copied Einstein's formula of E is equal to mc square, then it amounts to substantial copying. And suppose you had copied almost 60 to 70% of the notes that Einstein wrote on E is equal to mc square, it may still not amount to a copyright violation. So it all depends on the facts of the case. Now I talk about this, case which I filed against one of the movies quite recently. I was mentioning. Now this lady had written this book, and the book was titled Na Manasu Korindi Ninne. That was the title of the book. She had given certain sequences of how the hero meets the heroine, and when they meet, what was the dress the heroine was wearing, and things like that. There are certain, every story has got a plot, sequence, characters, all those things. It was all done. Then she gave the book to one of the very well-known producers. That gentleman went through the book and said, look, this sort of story anyone can write. Try to improve upon your story writing. So this lady thought that that advice was perfect. So she took back the book from him, the script, actually the handwritten script, and then she left for US. Then 8 months down the lane, one of her friends called up and said, look, a movie has released which has copied the entire content from your novel. Now that movie is produced by one of the top producers. In fact, I have filed a criminal complaint against the producer, and charge sheet is also filed against him. A very well-known and a well-liked actor has acted in that movie. a very well-known heroine is also there. Then this lady got completely disturbed. She said, "Look, they have copied my movie." So when she came and met me. She said, "Sir, a copy has happened. How do I go about it?" So I told her, "Look, if the movie is on YouTube, you see the movie, take your textbook, take your novel, and in YouTube you get the timing at the bottom, right? So take the timing and then refer it to the page where you have mentioned the incident and make a comparison, a comparative chart of what has been copied from the book into the movie." So this lady made a comparative chart and she found almost 33 similarities. I think it is 28 to 33 similarities that were found in the book and in the movie. So that was given to us. We filed a suit in the civil court. We were able to get an injunction on the ground that there was a substantial copying, not only of the story but also of the plot. Plot is very important in a movie, as well as the sequence in which it has been put, the way how it was put, as well as certain incidents that were revolving around the story in the movie. Now, based on this, injunction was granted to us. Of course, that injunction again, they are gone in appeal. It is before the High Court now. But what I want to tell you here is that an injunction is a possibility in the event you are able to show before the court a prima facie case, balance of convenience, and the irreparable loss you will incur if an injunction is not given. Then you have groundless threat even under the Copyrights Act, which is section 60. Same provisions apply. So groundless threat says there also, if a notice is given to you, you can approach the local court under section 60 saying that the groundless threat has been issued. So please give me a declaration that the threat is groundless, and then the defendant shall not continue with his threats. Then section 62 of the Copyright Act is also clear on the jurisdiction. It says the suit shall be filed at the place where the plaintiff is residing or ordinarily carries on his business. That is what is section 62, something similar to the Trademarks Act. Then you have section 63, which is offences of infringement. Now, when this, talking of offences of infringement under copyright and under trademark, let me tell you that if a seizure has to be done under the Trademarks Act, it is slightly a complicated process. So it is the officer of rank of a DSP who can enter the premises. And the first time he enters the premises, he cannot seize the infringing material. Now, this is not the commissioner which is appointed by the court. This is the officer who goes under the provisions of criminal provisions for a raid to be conducted. Now, he cannot seize the infringing material on the first account. What he has to do is he has to take samples of the infringing material. Then under section 115, he has to send the same to the registrar of trademark and obtain an opinion. In the event the registrar of trademark says, yes, both the infringing material as well as your material are same, then based on that, he can go for the second time, raid the place, and then, he can seize material. But this provision somehow is a very difficult provision, because the moment you raid the first time, by the time you go for the second time, all the material is clean. You will not get a single material. That is the problem with the raid under, through a police complaint under the Trademarks Act. With regard to the Copyright Act, that is Copyright Act, the raid under a Copyright Act is much more easy, in the sense that an officer of the rank of a sub-inspector can enter any premises just on a complaint being filed by the owner of the copyright. If the owner goes to the police station and files a complaint, the SI can immediately, the sub-inspector of police can immediately raid the premises. Now, let me tell you one thing very clearly. The Indian Copyright Act is one of the strongest copyright acts in the world. But the only problem that has been arising is the enforcement problem, where, the police is either not interested or they are not aware of what a copyright infringement is, or sometimes they say, all right, it is only a book, or only it is a label. What is the point, or what is it that you gain? So sometimes your work is compared to the economic value, and if the police thinks that the economic value is low, they think it's an exercise in futility for them to go and raid the place. So these are all some of the difficulties I had been facing, which I can share with you. Next slide. Now, nature of reliefs, same injunction at the ex parte stage or at the contested stage. Damages to be justified. When you seek a damage, you need to say, look, he has printed about 600 books of the story which I wrote. So he sold each book at the rate of 120 rupees. 120 into 600 is what I need to get the damage. So it has to be very justified. It cannot be what is called as a penalty on the dependent. Similarly, you have accounts of profit there. Then there is something called as a claim of acknowledgement, which is very important. See, if there is a claim of acknowledgement made, then the defendants can also seek, telling the court, we would like to settle it out of the court, please give us some time. There is a claim of acknowledgement there. Then groundless threat relief of injunction and damages is also there under the Right Act. The other order which I previously discussed in Trademarks Act, that is John Doe order, more specifically applies to copyrights than trademarks, because John Doe order is against an unknown person. So where there is an infringement happening of a particular movie, generally John Doe orders are given in stopping unlawful distribution of movie or illegal relaying of a movie through a cable. Okay. Next slide. Okay. Then jurisdiction 62(2), district court within whose local jurisdiction person instituting the suit or residing carrying on business. Jurisdiction wider than prescribed in the section 20. Jurisdiction same for groundless threat of legal proceeding. So under Copyright as well as the Trademark Act, if you are a registered, even under the, I think under Copyright Act, whether you are registered or not, you can still file under the, file before the court where you are residing and carrying on business. But in Trademark Act, if it is passing off, I forgot to tell you, in Trademark Act, if it is passing off, it has to go before the court where the actual passing off is happening. If it is an infringement, then the jurisdiction would be at the place of the plaintiff because he is the owner of the mark. So in trademark, there is a slight variation. Can you go to the next slide? Okay. What are the defenses that a person can take under copyright law? Fair use, that he had been using it fairly, and then it was, fair use is what is, it constitutes private and non-commercial use. I can copy some part of the content, and then if the permission is given to me, I can copy it and put it in my article or whatever it is, which is called as a fair use under private, and if I'm having usage of the document or the photograph or this thing as a private, like screensavers for your laptops, if you are having an image which is a screensaver, then it's private and non-commercial, you can use it. Now there is the second aspect of idea expression dichotomy. Now idea expression dichotomy, the subject is slightly large, so I do not want to get into it now. Maybe I'll try sending an article to Narasimha Rao sir where I had written about idea expression dichotomy. But the idea expression dichotomy is when you have an idea about writing a story, you don't get a copyright for that. You will have to put it on paper, write a story. Then only it has to be expressed on the paper. So once when it is written as a book, then you get a copyright for it. In fact, there is no IPR for an idea. It has to either take shape of trademark or a copyright or a patent or a design. Then only you will get a IPR for it. Then use for judicial proceedings, not much. Use and reproduction in legislature, not much. Recitation in public of reasonable extracts, yes, there are differences. Publication in collection for education, there are differences. In fact, quite recently there was a judgment by the Supreme Court, where on xeroxing of a material for education purpose, the Supreme Court said there cannot be a copyright violation. Now, though I don't completely agree with it, that case law is something to be discussed because it depended on certain facts which were very unique to that case. So the Supreme Court said, if you are xeroxing a book, a text, suppose someone has written a text on geographical indication and I don't get the book, I take the book, go to a Xerox thing and then Xerox it, then there is no copyright violation. It's a very, the judgment, I completely don't agree with it because at the end of it, the author has to be benefited for the work he has done. Can you go to the next slide? Okay, patents. Provisions of patents are slightly different from trademark and copyright. Now you have patents under section 104, jurisdiction is the civil court. Provision to section 104, you can file a revocation in the High Court. Now, let me tell you, I file a patent infringement in the local court, right? Then the defense that the defendant has is he can file a revocation in the same court. The application of revocation can be filed in the district court. And according to 104 of the Patents Act, the suit filed by the plaintiff as well as the revocation. Revocation here is not exactly like the revocation that is filed before the controller, but this is a counter claim. A counter claim. It can be saying, look, the patent that was granted to you should never have been granted because there are similar patents available, or the claims are so very, claims are do not qualify for being for a patent being granted. These are the grounds that you can take for a counter claim. So once when the defendant files a counter claim, both the suit as well as the counter claim gets transferred to the High Court. Then there is also this very specific provision of 105, suit for declaration of non-infringement after publication. Now once, okay, I'll come to that, with regard to the photocopying thing. I'll take the questions at the end of the session. Section 105, suit for declaration of non-infringement after publication. Now, you can file a suit for declaration of non-infringement. That is, if a person says you are infringing his product, you can file a suit and then say, look, because of these things, there is a non-infringement, which can happen only after the publication of the plaintiff's, of the defendant's, patent. Now, in a suit for non-declaration, when I am filing a suit for non-declaration, let us take I am filing a suit for non-declaration against Siba Gaigi, or I am filing it against Novartis, saying, look, the product that I am manufacturing is not infringing the product that is being manufactured by Novartis. So then what happens? Novartis will, Novartis will come out with its own defense, but Novartis's patent has to be published first. Then only I can file a suit for non-declaration, non-infringement. Otherwise, I can't file a suit. Then next 106, groundless set of legal proceedings similar to what is copyright and what is trademark, where I issue a threat to the person saying, look, you are infringing my process or you are infringing my product. Then he can go to the local court and seek for a declaration of groundless threat and request the local court to give an order to the patentee that he cannot give further threats like that. Then 107, defense of the defendant. Now, under the Patents Act, 107 gives various defenses that the defendant can take. 107A is an exception to the infringement. Now, many of the cases have been appearing for the defendant, especially for the, the active pharmaceutical ingredients manufacturers in Hyderabad, who manufacture this active pharmaceutical ingredient, which is like a bulk drug. So what the bulk drug does is it is like a vehicle which takes the actual drug to the relevant place in the human body. So suppose bulk drug is used, one of the bulk drugs is vildagliptin, which is used in tablets for sugar, BP, and all that. So there, what happens is, if I'm manufacturing let us say vildagliptin had patent till 2019, it expired in December 2019. But before that, a plethora of suits were filed across India against various bulk drug manufacturers saying they are manufacturing vildagliptin without, and there is an infringement happening. Now, the exception for that is if you read 107A, hello, yeah, okay. If you read 107A, 107A is a clear exception to the infringement which says that I can manufacture, I'm repeating, I can manufacture the patented drug, but in small quantities and not commercial quantities. One, two, that quantity shall be used only for research and development or for improving any other product. It shall not be for a commercial use. So I can manufacture the patented drug in my factory, but it shall be only for the purpose of what is called as for the purpose of research and nothing more. Then section 108 very clearly talks of what is the relief that the courts can give. As usual, regular, the injunction or appointment of a commissioner to go and then check a particular place. All this can be given by the courts. Next slide, please. Now, what are the natures of relief? Injunction either contested or ex parte. An option of plaintiff, at the option of the plaintiff, damages or accounts of profit, seizure, forfeiture, and destruction of material, and partial relief can also be given with regard to a valid claim under section 114. Now, see, the Patent Act has certain very, very strange provisions. Now, I can seek for a relief only with regard to one single claim in the patent, which is under section 114. See, section 114 is a very strange section. I'll just read out the head note for you. Section 114 says that relief for infringement of a partially valid specification. If in a proceeding for infringement of a patent, it is found that any claim of the specification being a claim in respect of which infringement is alleged, first it has to be a claim, then that claim you will have to allege an infringement of that claim is valid, but that any other claim is invalid, the court may grant relief in respect of any valid claim which is infringed. There are 10 claims and then infringement is happening only with regard to one claim. The court can give an order only to that particular claim. So that is partial relief under section 114. You will not find such a provision under any other intellectual property act, that is trademarks, copyrights or designs. You will find this only in Patent Act. Next slide, please. Yeah, jurisdiction. Section 104 only talks of filing of the suit in district court. It does not talk of jurisdiction. There is no provision under the Patents Act which talks of a jurisdiction. So automatically section 20 of the CPC is applicable. So infringement suits have to be filed at the place where the defendant is residing. Unfortunately, now according to me, this has to be amended, because patent infringement affects the patentee a lot. Because let me tell you, patent is granted for 20 years. So the patent infringement being done by an infringer affects the patentee a lot. If the technology is a very high-end technology, or the product is a very high-end product, and if the infringement is happening, it is a difficult proposition for the patentee to go to the place where the infringement is happening and then file the suit. Right? Next slide, please. Defenses. Now, research exemption under 107A can be a defense. Then patent exhaustion, exhaustion of rights, under the patents can be a great defense. Then invalidity of a patent or patent revocation, that the patent should never have been given, or the claims in the patent does not qualify for the patent to be given. All this invalidity of a patent or a patent revocation can be a good defense. Parallel imports can also be a very good defense, saying that there are parallel imports happening, so there cannot be a grant of injunction. Then non-infringement, that is, claims are not similar to the product. So non-infringement is generally non-infringement is taken in patents relating to pharmaceuticals, patents relating to what is called as what is that, biological and so molecular biology, things like that. There, claims are not similar is one ground that can be taken by the defendant, which is one of the defense. Next slide, please. Now, criminal proceedings. I've tried to bring everything in one or two slides. Now, section 104, falsification of a mark, I spoke to you. Section 103 is falsifying the mark. Falsification of the mark is different from falsifying the mark. Section 107 is use of R without registration. If anyone is using R, for a trademark which has not been granted, then it is an offense. Then section 63 of the Copyright Act, is criminal proceedings are spoken under the Patents Act, contravention of secrecy directions. See, once when an application is filed under the patent, so if the controller feels that your invention relates to defense, then he can give you a direction saying, look, you will not reveal it to someone, and these are called secrecy directions. If you contravene them, then it is a criminal, criminal proceedings can be leveled, proceeded against you. Then unauthorized claim of patent rights. Let us take, I filed a patent, out of which during the FER, that is the first examination report, when the controller said, look, out of this 20 claims that you have filed, I can't grant you 7 claims, so you remove them. So what you do is you amend your claims and then refile your application, amend your claims and then you file your reply to the FER. That is granted to you. Tomorrow, you can't claim that the claim that you had relegated is also part of the claim. So unauthorized claim of patent rights, one case which we recently dealt against one patentee, where there was a claim of a right on a claim that was discharged by the patentee himself. So there we were able to get some criminal proceedings initiated against them. Then working of patent information, if not supplied at the request of the controllers, yes, this is a very important thing. Working of patent information has to be supplied to the controller whenever he seeks for, and most of the time it is cheating 420 for the above 3 contraventions that are there. Next slide. Yeah. Criminal jurisdiction, above sections relating to offence and penalties and other proceedings. 107 talks of falsely presenting a trademark as registered proceeding to initiate before the registrar. 102 and 3, it can be filed in a regular police station or through a private complaint. The punishment is for 3 years, penalty is up to 3 years. 104, for selling goods or providing services with false trademark. Again, that can be a criminal offense also. Section 111, forfeiting infringing material in case of conviction, under the provisions of CRPC, this can be done. But you can also seek for a release of this material from the same court. Then section 115, police officer not below the rank, I told you. or a deputy superintendent of police can conduct a search without a warrant. So there are all certain problems which have to be sorted out. Let me tell you, IPR Act still needs some amendment here and there, and then to fine tune it. Next slide. Yeah. Factors for grant of injunction. I'm talking about certain cases. Whether plaintiff has a prima facie, whenever you file a suit and then you are arguing, there are three things that you need to establish beyond any reasonable doubt before the court. First is you have a prima facie case in your favor. Prima facie case can be the copying of the trademark is similar. It is copying of the trademark is phonetically similar, or copying of the trademark is deceptively similar, or the copying of the product, the infringement of the patent is exactly the same without alterations to the claims and all that. So that is one, that can I have the slide? Yeah. So prima facie case is extremely important. Then next, balance of convenience lies in favor of the plaintiff. Now, balance of convenience should lie in favor of the plaintiff. That there is a prima facie case that the plaintiff has proved. So the balance of convenience lies in his favor. Then the third important thing is that the plaintiff would suffer irreparable loss if injunction is refused. Suppose an injunction is refused, the infringement might go on, and the plaintiff will suffer irreparable loss, which even at the end of the suit, if he is able to recover, but still he would have lost lot of still he would have suffered injury which cannot be repaired. So this was laid down first in the 1996 Supreme Court case of Colgate-Palmolive. This case did not deal with the IPR issue. It dealt with monopolies, restricted and trade practices, but it followed in 1991 case of Supreme Court in Wander versus Antox. So if you have to know the factors for grant of injunction, please read both these judgments, because in the Colgate-Palmolive judgment, the 1991 Wander versus Antox case has been completely discussed. Next one. Next slide, please. Yeah. Then jurisdiction under 134, you have these two cases where under EIR 210 Gujarat, it has very clearly stated that once when the law very clearly says, notwithstanding any other provision contained in CPC, then automatically the jurisdiction comes under the provisions of that particular special act. So that is what has been laid down. Then 2015 66 PTC, Syed Mohiddin versus Sulochana Bai. I told you, prior user is a very powerful user. I would recommend everyone to read this judgment. This judgment has dealt with who is a prior user. It has dealt with who can file a suit if both the parties are owners of a mark. There what happened, the defendant was also owner of the mark and he was using the mark for 40 years. Whereas Sulochana Bai was using this mark for more than 100 years. And then this related to what is called as Tirunelveli halwa. The halwa that is manufactured, that is prepared in Tirunelveli, has got a great taste for its, the way the water that is used and the way it was, prepared. So Sulochana Bai had a brand. She did not even have a name board. Let me tell you, if you read this case, you will get all the facts. Sulochana Bai, who was the initial plaintiff, she did not have a name board. The business she was carrying on was more than 100 years old, and it was called as Irittu Kadai Halwa. That is, Irittu in Tamil means dark. Kadai is the regular kadai which you use to cook. Halwa is the product. Why it was called as Irittu Kadai Halwa was that shop had a small, what is called as a candle or a wick that was burning from oil before the electricity came. Even after the electricity came, there was only one single bulb, and it was that lady never even had a name board or anything like that. So this Mr. Syed Moinuddin started Tirunelveli Iruttakadai Halwa as a competing mark, and so he was restrained. So this case is extremely important. I recommend everyone to read it. Then the next one is the Neon Labs case, which was also referred in the the Sulochana Bai case. Neon Labs case also says first to enter into the market is to be protected. Even though the later entrant could be a registered user, the first who has entered, who may not be a registered user, has to be protected. Then distinction between infringement and passing off you will find in these cases of Ruston Hornby and AR 1965 Supreme Court. They both are Bible insofar as what is the difference between infringement and passing off. There are innumerable judgments that I can give you, but these are the judgments that made a milestone for the courts to follow. Next slide, please. Then the other important factors to be considered for infringement, if you read the Parley products, it very clearly says what are the essential features to be considered. Parley product says when the judge is looking at an infringement, he need not look at specific things. All that he has to see is if on the overall examination of both the marks, that is the original mark and the infringing mark, if the infringing mark looks similar to original mark, then you can grant an injunction. So essential features to be considered is what has been laid down in this Parley products case. Then in an infringement or a passing off, injunction must follow. I have missed the word injunction there. See, if there is an infringement and if in a passing off also it is shown that there is a passing off done, infringement must follow is what the Supreme Court, if you read Supreme Court Maitas IG, it's hardly a 2-3 page. If you read it, it very clearly says where one of either a trademark or a copyright, the courts have to give an injunction. That is the language that has been used there. I use that case very often to get injunctions in the lower court. Next slide, please. Next, yeah. Then important statutory monopoly conferred owner to have primary precedence over other considerations, except under section 28(3), where the prior user, where the one of the parties is a prior user, this may not hold good. Then registration establishes prima facie case in favor of the plaintiff. That is what I was telling you. Once you have a registration, you file it in the court, it is presumed, it is taken by the court that you are the owner. You don't need to again prove your ownership before the court. So you will have the Avis footwear, which is a very important judgment of 1991. You can read it, it's about 4 pages judgment. Then, apart from this, there was this triple identity test that was deployed by the Delhi High Court in Ozone Spa case. Now, what is this triple identity test? Marks are identical, goods and services are identical, class and customers are same. If a mark is identical, if the marks are identical and goods and services are identical and class of customers are the same, that is students going to, I had this very interesting case where I appeared against ISB a few years back. I was appearing for a client from Calcutta whose logo was also ISB. He claimed himself to be International School of Business, whereas the Hyderabad school claimed as Indian School of Business. The simple ground that I took were two. One is the class of customers. In both the cases, it is the educated who go. So I can't take a train from here to Calcutta thinking I'm going to Indian School of Business in Hyderabad. One. Two, International School of Business or Indian School of Business, both of them have been brought in as an acronym as ISB. So any acronym which has got 3 letters is a bad trademark. That is what the contention I has taken. So there also, ISB lost its case. They could not, get an injunction against me. So this is the triple test that has been laid down by the ozone spa case. I'll try giving the citation. I don't immediately have it, but I'll try sharing it. Next slide, please. Yeah. Then passing off, it's a common law, right? As I told you, passing off arises under the common law. So 1950, when the first act came in 1957 or 56 Trademarks Act, prior to that, it was not, people were not copying the trademark.
Okay.
Whoever was copying had to file under the specific relief act. So if you read these three judgments of AIR 1941, 1940 Madras, and 1923 Mumbai, you will get to know how the cases were being handled prior to the Trademark Act coming into place. Now, Trademark Act came in 1956 later, but it had only goods as part of the classification.
Mama, just for your protection. Otherwise, Arthur might come and trouble you. Whatever you say.
Can I
Everyone
have
is
the
requested to
Ah,
please
oh, yeah.
mute yourself.
Mama, someday Arthur will come and beat you today.
I request everyone to please mute yourself.
Okay. Are you able to hear me now?
Yes, sir.
Mr. Mondal, are you able to hear me now? Okay. Now, prior to 1956, it was only the Specific Relief Act. What you can see here in the slide are the three judgments. Kindly read it. Then you will appreciate how trademark passing off cases were being, dealt with
Website of the library.
prior to the Trademark Act. Now, whether defendant has represented goods as if sold by plaintiff is one, then deception in public. These are all the important, these three judgments will give you that. Next slide, please. Yeah. Now, this is a very important judgment of the Supreme Court, Lakshmikant Patel versus Chetan Bhai Shah, which I very regularly use it when people say we never knew that the plaintiff was existing. Now, injunction, it is not injection, it is injunction. Injunction can be granted even if adoption is innocent by the defendant. If you take 121 Supreme Court case, read it along with this 2002 Supreme Court case, you will form a very formidable case in your favor if your trademark has been infringed. So, and the second thing that this judgment says is non-grant of injunction. Sorry for that mistake. Injunction is my office made the mistake. Non-grant of injunction becomes failure of justice is what has been stated in this case. Now, there is one more case of the Karnataka court which I remember. It was passed in 2018. This was pertaining to some stationery brand. I will try sharing that. There, what happened? I appeared in that matter. There, what happened when the lower court, when the case was filed before the lower court, notice was ordered. Though there was a prima facie case established, notice was ordered on the other side. Injunction was not granted. So a writ petition was filed in the Bangalore High Court, where the question of saying that the court can be a mute spectator, but it has to actively take part in analyzing the case and granting an injunction wherever necessary. So I'll try to share that case. I need to share two cases with Mr. Narasimha Rao. I'll try sharing that. Next slide. Okay, so that is the end of the presentation. Now I would like to